That's what I'm wondering, unless she was just told.
Yeah, maybe she just got the call or something.
But it's a bit bad, isn't it?
Yeah, that's a lovely.
Is she not coming back?
I don't know. I haven't got it yet.
They're all out there.
I don't know.
Not sitting both. I don't know where the third clerk is. You're not going to see the third man, are you? Would you mind? I don't know where she is. Unless she's coming. Yes. All right.
Yes, Mr. Lawrence.
Well, thank you. The court should now have, and I'm sorry it wasn't there before, it should now have the words of the man himself from 1924.
Thank you very much.
Which I will go to briefly in a moment, if I may, having seen how the law is analysed in the most recent edition, which, as I've said, is a very recent work. I think it came out about a year or two ago. So we had reached, I think, tab 14, page 248 of the bundle.
Yes.
And I had emphasised the very important distinction that is taken between, that is drawn between the prohibition of contradiction and the prohibition of reassertion. That distinction is in sharp focus here because my client wishes to rely on the declaratory judgment in order to prohibit contradiction in these proceedings. So my client we seek to invoke the wider principle of res judicata here, but my learned friend is seeking to rely on it in order to prohibit reassertion. This chapter, then, if I can ask the court to go over the page, continues into a section headed rationale, which
Sounds promising.
begins by stating that the doctrine of former recovery has been justified on 3 grounds, 2 of which apply to res judicata estoppel. And then the court will see that there's a reference first to the general interest in the termination of disputes, second, the interest of the individual litigant in not being vexed twice, I'm paraphrasing, and then third, the third, merger, only applies to the doctrine of former recovery. Any cause of action for which judgment is given by an English judicial tribunal merges in that judgment, transit in rem judicatam, or partem. The cause of action ceases to exist and cannot support a second action. And so it goes on. I don't think I need to refer expressly to anything more in that section. And then the last section in this chapter, 1903, identifies the 6 elements that a party setting up a former recovery, which is interchangeable, as I say, for a plea of merger, the 6 elements that such a party must establish. And it is the first element that is material here, namely that the former judgment can, in law, support the plea. That is the question for the court. Can a declaratory judgment support a plea of merger, or, as Spencer Bauer would put it, former recovery? And that then leads one to the next page, chapter 20 in the 5th edition, which is entitled What Constitutes a Former Recovery? And it is this chapter which I submit is of critical importance in this appeal, and is really, if it correctly states the law, is determinative. It starts, for present purposes, the res judicata means a judicial decision or award granting relief. There it is, the troublesome word, relief, again. may kindly read swiftly what follows, I'm going to go on to the foot of the page. One reaches the last paragraph on the page. If performance by either party cannot be enforced, the decree can be rescinded. The contract will then revive and can be terminated by the court. I read that. I don't, in fact, think that is pertinent. Then this. The following do not qualify as a judgment granting relief for present purposes. A declaration of right, that is the point at which one would, at least I would want to see a footnote, maybe my own friend would too, but we don't. A declaration of right, and then various other matters which do not qualify as a judgment granting relief for purposes of the present discussion. C's the other matters. I'm not sure they provide very much assistance in developing the analysis. Then, if one turns over the page, 20.02 deals with arbitration awards. 20.03 deals with foreign judgments, in relation to which the old rule that foreign judgments weren't good enough to support a plea of merger was abolished by the 1982 Act. And then 2004, under the heading recovery, says this: formal recovery is established by proof that the party against whom the plea is set up obtained as claimant, counterclaimant or the like, a judgment or award on the same cause of action. Again, one has these semantic issues. What does that mean, on the same cause of action? Is it enough for there to be simply or merely a declaration which concerns the cause of action? Or does it, as I submit, need to be a judgment in the coercive or executive sense, typically a judgment for the payment of some money? The text goes on: a plea of payment under a form of judgment can be established without proving that the judgment was a bar. Whether there was a form of recovery is a question of fact. And then this, 20.05, this is quite instructive. Recovery does not mean satisfaction. The plea is good, although the judgment is unsatisfied. The right to execution under it has been abandoned, or the claimant had abandoned part of his claim to bring it within the jurisdiction of an inferior court. It is no answer that the plaintiff recovered less than he would on another cause of action. The point being made there, I submit, is that in this context, what is being recovered is not money. This is not a rule against double payment. What is being recovered or obtained is the judgment itself. And the rule, the doctrine of merger, is a rule against obtaining judgment, in the sense for which I contend, twice on one cause of action. So 20.05 is, as I submit, instructive. It's not, I don't say that it's decisive, doesn't in terms set out the principle for which I contend, but it is entirely consistent with the analysis that I am putting before the court. 20.06 doesn't concern us, and then over the page, just completing this chapter, 20.07 is dealing with jurisdiction. It's not relevant to the present discussion. And then 20.08 is a passage under the heading finality. And it makes the point for which I contend, it sets out the proposition for which I contend. For a second time, the form of recovery must be a final judgment capable of supporting an action. Just pausing there, what does that mean? What does capable of supporting an action mean? I would suggest that respectfully, that means a final judgment that is enforceable, and capable of supporting or founding enforcement proceedings.
There is a footnote there.
Yes, I'm going to tell the court what I made of that footnote.
Okay.
Because there are two apparently very encouraging footnotes, but I'm going to inform the court in a moment that they are false trails.
All right.
They lead nowhere.
Oh dear.
Right. I was excited to see footnotes 1 and 2, but
They don't help.
I've been down that road.
They're both internal cross-references. They're not to any external authority.
That's right.
Yes.
That's right, Lord. So the next sentence makes my point again. Sans authority. Other final judgments which will support a plea of res judicata estoppel, such as declaratory judgments, will not support this plea. The party pleading for a recovery must prove that the judgment was complete and final, and nothing further had to be done judicially to render it effective and enforceable. I do submit that it's reasonably clear that the author is contemplating that in order for a judgment to support a plea of murder, it must in some relevant sense be an enforceable judgment in a way that a declaratory judgment is not. And that is what one gets from the 5th edition of Spencer Bauer, the key passages being the passage at 19.01, which draws in prohibition of contradiction and prohibition of reassertion, and then the two passages, one at 20.01 and the second at 20.08, which say in terms that declaratory judgments cannot support a plea of merger. So that's the position, as set out, I suspect, principally by Mr. Justice Handley in the 2019 edition. I think that's the right date. May I then, I was going to invite the court to compare that with what was said in the 2nd edition, but now as a result of a little scooting around, I've got the words of Mr. Spencer Bauer himself from 1924, right, which I hope have reached the court now.
Yes, thank you.
And it's interesting to compare, and there's no real contrast, I think, but to compare the position as set out originally and as it is now expressed. So the chapter numbering is different. The original edition is covering this ground in part 2, as the 5th edition does. But we're not looking at chapter 19 here, we're looking at chapter 1 in part 2, which is the equivalent of chapter 19 in the 5th edition. The text at 294 is familiar. It is similar to the opening words in chapter 19, although for obvious reasons Mr. Spencer Bauer was not able to cite Lord Justice Diplock in the third day, which was a 1964 decision. Then the passage at 295 again is familiar in that it draws the distinction, which I submit is key, between contradiction and reassertion, but it's expressed slightly greater length and in terms which I submit are of some interest. So it's headed, Mr. Spencer Bauer heads this passage, general statement of the doctrine. And if one reads down about 6 lines, one finds this: a bar or plea of this nature, known as formal recovery in civil and autrefois convict in criminal cases, is essentially distinguishable from the estoppel per rem judicatam, which has hitherto been the subject of inquiry in 2 respects. In the first place, the latter prohibits contradiction, the former repetition and reassertion. That's familiar and draws the same distinction. Then one sees this. Secondly, that which must not be controverted in cases of estoppel is the proposition of law or finding of fact expressly declared by or necessarily involved in the res judicata, comma, the yusiv or prohibited part of which is of no importance whatever, except so far as it presupposes a determination of such question of law or issue of fact. So, pausing there, I submit that the author there is making this point. He is saying that when one is in the territory of estoppel per rem judicatum, or catam, i.e. the territory which prohibits contradiction of a previous judgment, then what matters is the proposition of law or the finding of fact that has been arrived at by the court. What matters is the content of the court's reasoning and findings. And it is that content which cannot thereafter be contradicted by those who were parties to the first action. And the, if I'm pronouncing it correctly, yusiv or prohibitive part of the court's judgment is of no importance when considering this aspect of the res judicata doctrine, which is concerned with the prohibition of later contradiction. Then the author goes on, and this is an important passage, whereas in cases of former recovery, I interpose, i.e. merger, the situation is reversed. The thing which is not allowed to be sued for a second time being the relief and remedy granted by the yusiv or prohibitive part of the res judicata, and the judicial determination, express or implied, of any question of law or issue of fact being as such absolutely irrelevant. And this passage, I respectfully submit, does indicate the reasoning which underlies the proposition that declaratory judgments do not support a plea of merger. This passage indicates that when one is considering the application of the doctrine of merger, what matters, what is important, or in fact what is necessary, is that the litigant, the successful claimant in the first proceedings, has obtained, and I quote, relief and remedy granted by the yusiv or prohibitive part of the res judicata. And expressing that slightly old-fashioned language in modern colloquial terms, what is necessary, I submit, for the doctrine of merger to be engaged is for the claimant in the first litigation to have obtained a judgment of the court which either says, typically, to the defendant, you must pay up, you must pay X, or which may say, in negative terms, to the defendant, you may not do Y, an injunction restraining the defendant from doing Y. I think that's what is meant by the phrase yusiv or prohibitive part of the res judicata. And there you have relief and remedy in the relevant sense, because the litigant has placed the relevant fact before the court, proved the elements of the cause of action, and obtained a judgment which is immediately enforceable. The successful claimant can then immediately invoke the power of the state to exercise force legitimately. Again, putting it colloquially, either by sending in the bailiffs or by putting a contemnor in prison. And it is at that point that the doctrine of merger is engaged, and it is a litigant who has achieved success in that sense who may be subject to the absolute bar against further proceedings, which is imposed by the doctrine.
So is Yusuf, or however one pronounces it, the same as imperative?
I think so, yes.
It seemed I've just been looking it up. Seems to.
Yes.
According to the online Cambridge dictionary.
Yeah.
It's the form of a verb that's used for giving an order. That's what it says here, but that's not an authoritative source.
But that's
online.
Well, they both come from Latin verbs, which
Yes.
are synonyms. Ubio on the one hand and impero on the other.
Indeed. Mr. Spencer Barr was a very distinguished classicist.
As I see from the quotation from Sophocles on the front page.
Indeed, and your Lordship has also seen, I suspect, on the front page that I didn't do him full credit. I didn't give him full credit. He's the author of 4 works, plus, etc., etc. So he was a prolific author, and
Will you just read us that Sophocles?
I will rely on my lord to my right.
there is a member of the court where I might rely, but I'm not going to risk that. I can understand it, thank you very much, Mr. Temming, but I'm not going to risk it. He was a prolific author. His works.
But I mean, just coming back to this.
Yes.
I mean, I don't. This is quite sort of. I mean, are we sure he's talking about the same thing? I mean, what the particular passage you light on looks very like the second category in Lord Sumption's list in paragraph 17.
Yes.
In Virgin, where the claimant succeeded in the first action, doesn't challenge the outcome. He may not bring us on the same cause of action, for example, to recover further damages.
Absolutely.
Looks very like that. But then the third principle, the third species, is what Lord Sumption refers to as merger.
Your Lordship is ahead of me. I'm going to come to Virgin in a moment, and I will submit that when one looks into the bottle and examines the contents of the bottle rather than the label with care, there is no real difference between the second and third categories in.
Okay, I see.
In Lord Sumption's list.
Right.
I will seek to make that good if I may when I come to that case in a moment. So just staying with the 1924 text, please, if I could ask the court to look at 2 further passages shortly. If I could go to page 177 of the text. Section 299. Mr. Spencer Barr is discussing the underpinning, the foundations of the rules about merger, or the doctrine of merger, and he's identified 2 familiar policy reasons that policy matters that underpin the rule. And then at 299 he goes on. There is, however, a third theory on which the bar of former recovery has been rested, but which in no way supports the rules of estoppel. This theory, fully developed in Cook's time, though not perhaps meeting with universal unqualified acceptance in the earliest periods of our jurisprudence, is of the following nature. Any cause of action which results in a judgment of an English judicial tribunal, whereby relief is granted to the plaintiff or other actor in the proceedings, is in contemplation of law merged in the judgment as soon as pronounced, and thereby loses its individual vitality and disappears as an independent entity. Any English judgment, even of the lowest degree, being regarded as of a higher nature than any, even the most important cause of action. Then the Latin tag, whence it follows that after such passing and absorption, it cannot be the subject of further action proceeding to the recovery of similar relief. Again, we have the concept of recovery of relief. And then this line, strongly though it savours of scholastic metaphysics, this view is perhaps, after all, the only one of the 3 which completely accounts for and justifies certain features in the doctrine of formal recovery which differentiate it from the doctrine estoppel.
I'm going to go to footnote W. Do you want to deal with it now? I mean, read it, or shall I?
My learned friend is going to go to footnote W, which is quite long. I think it probably makes more sense for him to do that.
Well, we'll read it to ourselves now.
Yes, thank you.
Yes, these things are always, I mean, we in a sense always come back to what they mean by a cause of action, don't we?
My lord, yes, one comes back to that concept, one comes back to the question of what is meant by recovery of relief, and one even comes back to the question of what is meant by judgment on a cause of action.
See, it's quite, this observation doesn't help resolve this case, but just going back to what Lord Sumption said, because it rather ties in with what is being said here. He said of merger that although it produces the same effect as the second principle, it is in reality a substantive rule about the legal effect of an English judgment, which is regarded as of a higher nature and therefore as superseding the underlying cause of action. At common law, it didn't apply to foreign judgments, although res judicata did, and then of course he refers to section 34, which is why I'm sort of puzzled by the idea that an arbitration award can give rise to merger. I mean, I could see it could give rise to some form of estoppel and so on, easily. But why a merger if it seems, the way Lord Sumption puts it, which is entirely consistent with what is being said here, is that it's something to do with the nature of a judgment, a common law of an English, limited by the common law to an English judgment, extended by statute to a foreign judgment.
Yes.
Now, it doesn't necessarily, I mean, as I say, it's not an observation which provides the answer here, but it's helpful to try and understand the doctrine with which we're trying to grapple.
Yes. My lord, I don't disagree with any part of that, of the reasoning underlying that observation, and the position of an arbitration award is potentially problematic, and I would also respectfully submit that the position of an ombudsman.
I was going to say,
Well, I would
that
have thought,
seems to me
yes.
even more an
Well,
extraordinary case.
Yes, which may be why Lady Justice Arden did not base her judgment on merger.
Exactly. Exactly. I'm going to demonstrate very shortly to the court, and the court may already have picked it up, that one can see from passages in the judgment itself that Lady Justice Arden plainly did not take herself to be deciding that case by reference to the doctrine of merger.
Yeah, well, that I think is reason. Yeah, thank you. Okay.
So, just completing there's an amusingly archaic passage about the merits of English judgment when compared with foreign judgments, which are technically described as non-English judgments, but I'm not going to take up time with that. It reminds one that this was written quite a long time ago. But the passage that, just to complete this look at the original 1924 text, the final passage that I should draw attention to is on page 179. This is chapter 2 of part 2 in the original text. It's the equivalent of chapter 20 in the 5th edition. It's headed in the same way, what constitutes form of recovery. one goes to the foot of the page, section 304, one finds substantially the same passage as that to which attention has already been drawn, but the language used is slightly different. The following do not satisfy the requirements mentioned, and therefore are not deemed, quotes, judgments, close quotes, for the purposes of the plea of formal recovery. And then Mr. Spencer-Bauer uses this phrase, a naked judicial declaration of rights and liabilities. And I would respectfully submit that the addition of the word naked there is indicating that a judgment doesn't qualify for merger purposes if it is only a declaration as to the true legal position. But it may do, or will do, if it is a declaration coupled with coercive or executory relief. May I then please take the court to a short passage in the Chief Master's judgment, which contains a useful citation of Zamir and Wolf on declaratory judgments. So that is at tab 12, page 139. Tab 12, page 139.
Have we got Zamir in the bundle of authorities? I mean,
No.
supposing we were interested in having a look at it.
We haven't, my lord. Again, it's really a nil return.
Yes.
I've looked at it, and I think my own friend has as well. And I maybe possibly take more from it than my own friend does, because there is nothing in that work, which is all about declaratory judgments, obviously.
Yes.
There is nothing in that work, so far as I can see, at all about the doctrine of merger.
I quite follow that. I was more interested in the general juridical nature of the declaration in English law, as to whether that might perhaps help throw some light on the question, or whether one can legitimately treat it as as a category rather sui generis.
Yes. Well, there's obviously a lot in Zamir and Wolf, and it may be that unless the court is giving judgment this afternoon, which I doubt, it may be the council can assist by providing some short excerpt from it. This passage here, which I think I did cite to the Chief Master, is a useful start, certainly. It defines, at paragraph 41, towards the top of the page, it defines a declaratory judgment.
So it's, sorry, just give me the reference again.
Page 139, tab 12.
Thank you. Yeah, paragraph
41.
41. Yeah.
Thank you. This is a passage from the introductory section in Zamir and Wolf. A declaratory judgment is a formal statement by a court pronouncing upon the existence or non-existence of the legal state of affairs. Yeah. It is to be contrasted with an executory, in other words, coercive judgment, which can be enforced by the courts. In the case of an executory, and so on, your lordships will read what follows. And that passage very succinctly draws the distinction which I place at the centre of my argument.
I mean, it does make the point that any legal judgment which leads to a sort of a coercive remedy has two elements to it. One is establishing the right, and the second is what is the positive order of the court consequential upon that.
Yes.
And the point, I think your essential point is that the declaration is only half, so to speak, of the overall process, which results in a court order forcing somebody to do something.
Well, that's right. And in fact, the text in this this textbook makes the point somewhere that the jurisdiction to make declaratory orders is one mark of a sophisticated and civilized legal system. And one reason why that is so is because the existence of that jurisdiction enables parties who are not presently forensically at war, but who disagree about the meaning of a contract or some other legal issue, to take it to the court, and often seen in the context of trusts and so forth, and take the matter to the court and obtain binding clarification as to the true legal position. And one can conceive of a case in which, one can easily conceive of a case in which the declaratory jurisdiction might be invoked in that way, partly to avoid inflaming the relationship between the parties and generating hostility. For instance, may I, I've been contemplating this, may I put this hypothetical example to the court and see how it fits with my learned friend's analysis. Suppose you've got a long-term contract, which is working reasonably smoothly, but it contains a provision which provides for regular payments, say annual payments by one party to the other, and there is a dispute as to the proper construction of that provision. The paying party has been paying at, say, £100 a year, and contends that the proper construction of the clause requires that sum to be paid. The recipient disagrees and says that on its proper construction the clause requires the payment of £1,000 a year. Payments at a lower rate have been made for a number of years. The contract is otherwise working perfectly well and the parties have no interest in bringing it to an end. But they do need to sort this out. There is an alternative construction which would result in payments of, say, £200 a year. The matter is placed before the court in a reasonably amicable way by the parties, seeking a determination by way of a declaration as to the proper construction of the contract. The court considers the matter, arrives at the intermediate, holds that the intermediate construction is the correct one, so that the sum that should be paid and should have been paid in the past is £200 a year, not £100 a year. The parties say thank you very much. They have clarity, they go away, they continue with their contractual relationship. It is expected that an account will be taken and proper payments will be made. But at some later time they fall out and the matter returns to court in new legal proceedings and they are now at war. As I understand my learned friend's submission, the failure of the payee to obtain, at the time the declaration is made, an order, judgment, for the sum that is due in respect of the previous shortfall, means that the payee is then shut out. And that would not merely, I respectfully submit, be harsh, it would be absurd. The parties there have invoked the court's declaratory jurisdiction in an entirely proper way, and there is no reason at all why, when they come back to court, why either party should be barred from advancing any case that it can properly advance on the basis of the law and the contractual construction as declared by the court. So, all of that, if that is a fair hypothesis, that strongly supports, I respectfully submit, the argument that the answer to all these problems lies in treating the flexible Henderson and Henderson jurisdiction as being applicable to cases where parties seek declarations and might at the same time be expected to seek coercive orders, but not as taking the very significant further step of treating the inflexible, wholly inflexible doctrine of merger as being applicable to this type of case.
But in a different case, if you sought a coercive order and obtained it, you couldn't go back for a further coercive order arising out of the same cause of action, but dealing with a different subject matter. I mean, the reason I put it that way is, as you were just giving your example,
yes.
I was thinking of Farrer and Leon Green, which is the Court of Appeal case, about a possession action.
Yes.
But there, of course, it wasn't a declaration that was sought, it was a possession order.
Indeed.
And the argument was, wasn't it, I think, that the landlord couldn't go back for mean profits for the period before possession was obtained.
Indeed.
And the Court of Appeal came up with a way, if I can put it that way, of avoiding that result.
Yes.
But if yes, so the critical the point is that it goes back to the declaration.
Yes. The Farrer case, which my own friend cites the Farrer case, but in fact it's I would submit it's a case on very much on my side of the argument, because the Farrer case is, if anything, a stronger case for the parties seeking to apply the doctrine of merger, because in the first set of proceedings, the successful claimant obtained a real judgment, a coercive judgment, a possession order. You must leave the premises.
Yes.
But omitted to obtain the ancillary monetary relief for mean profits. And then when in subsequent proceedings a claim was made for money, the departed tenant took the merger point effectively.
Yeah.
Was in a strong position to do so, I respectfully submit, than the defendant in this case, but failed.
Well, failed because it was a different cause of action.
Yes. Yes.
Because you've got every day there's a new trespass.
And
So
in your
because-
case, your example of the long-term contract, if there had been a money claim at the time of the first proceeding in relation to
Yes,
the money
indeed.
then owed,
Yes.
but there was later another claim in relation to monies that had become due, there wouldn't be any question of merger being a problem.
I respectfully entirely agree, my lord, that there would not. The further sums that became due pursuant to the court's instruction following the date of the declaratory proceedings could not be the subject of a bar based upon merger. What could be and would be, I submit, if my learned friend is right, barred by merger, would be the claim for sums that should have been paid in the past, which in a civilised way, on the hypothesis that I'm putting to the court, the other contracting party, in relation to which the other contracting party did not seek a monetary judgment in the declaratory proceedings. One can see all sorts of reasons why that might be considered to be the correct approach. So that is taking the court to the passage from Zamir and Wolf that was cited by the master. If there's anything else in that textbook which seems very pertinent, then I may seek leave to bring it to the court's attention in due course, or very shortly. But I don't believe there is. Of course, in the CPR, CPR 40.20 deals with declaratory judgments. The court will find that. I don't want to go to it now, time does not permit, but the court will find there quite an interesting but quite familiar treatment of the jurisdiction and the way in which the jurisdiction has widened to some extent over the last 40 or 50 years. And in fact, looking at that, I was taken to a judgment by Lord Justice David Richards from about 8 years ago, with a Greek name, in which your lordship considered the widening of the jurisdiction since the Poirier case in the 70s.
Yes. I do remember that. Yes.
I take it we may assume that all other textbooks in this area have been looked at and don't deal with the issue at all. Is that right?
I've done my best, Lord. Yes. Yes. There isn't much more.
I can't believe, probably aren't many textbooks. Certainly, as far as I'm aware, Spencer Bauer is always treated as the leading textbook in this area.
Yes.
Which I suppose leads on to another point. Obviously, courts in this country are far more prone or far more willing to base their judgments on academic writings and textbooks, where obviously they think it right in law, than they were in the past. On the other hand, so I suppose really I'm saying you have on your side a highly respected textbook statement, repeating a statement in your, which goes back for the best part of a century.
Yes.
And that is something we can legitimately, I would have thought, give some weight to.
I do.
It's not enough really just to say that's just another lawyer's opinion. It's a good deal more than that.
It's a good deal more than that. It's a good deal more than that. Mr. Spencer Bauer plainly was steeped in the jurisprudence of the 19th century.
Sounds like an addict subject.
He could be said to have been addicted to it. He was steeped in it, and he set out that proposition. He had some reason to, and I sought to indicate why that might be. But he set out that proposition in 1924. It's two distinguished jurists from the other side of the world have adopted it. It's been there for almost 100 years, and that takes one to the gap in my learned friend's case, which is the absence of any previous case that we are aware of in which a pure declaration or declaratory judgment has supported a plea of merger. He has not and does not claim to have identified any such case. And my respectful submission is that if the doctrine for which he contends was a good one, then that gap in the authorities is very surprising, because as the debate that is being conducted today indicates, if declaratory judgments can in law support merger arguments, then it is inevitable that there will be difficult cases turning on their own facts in which the courts grapple with the interrelationship between declaratory judgments and the hard-edged, inflexible doctrine of merger. But there is nothing. Instead, I've got almost 100 years' worth of support from the leading textbook, and I do respectfully submit that should carry a good deal of weight with this court. May I then, having made that point, may I then just make some short submissions about the 2 or 3 of the leading cases? I'm not going to go into all the subsidiary cases for a reason I would explain, but I think I should make a short submission about the 3 or 4 leading cases. The 2 cases in the bundle of authorities that appear to me to be true merger cases are the 19th century case of King and Hall. And
well, is that a true merger case? Because I mean, it was concerned with the effect of judgment against one of 2 or more joint obligors, which is a very different thing from merger, which we're talking about here.
Yes, as I read it, Noel, I think it was a true merger case.
I see. Right.
If I hadn't been, I meant to check this over the short German. I was scurrying over to the Lincoln's Inn Library. I think I'm right to say, and I'll correct this later if I'm wrong, that the law has changed.
Yeah, I think you're right.
Since then.
I think you're right. But I just wondered actually whether the actual case was concerned with the sort of merger we're concerned with, at any rate.
Well, maybe that I haven't looked deep enough into facts, but the text it's tab 1, page 210, so internal page 504 in the original report. That part of the judgment certainly speaks of merger.
Well, I absolutely accept that, and yes. I mean, all I'm saying. All right. So, in other words, what Baron Park says there is talking about merger. I see that.
Yes.
Yes. What I meant, in a sense, what I was meaning was the actual decision in the case is not what we're talking about.
No, it's not.
I understand it.
It's not on all fours with the situation that we are addressing in this case because of the existence of joint.
Yeah, exactly. That's what I had in mind.
I respectfully.
All right. Okay. All right. Well, anyway, there's King and Hall.
There's King and Hall, which, subject to the qualification your lordship has mentioned,
yes,
is always treated as containing the.
It is treated that way.
Yes.
A very helpful definition of the doctrine. And again, what is said in King and Hall about merger is consistent with the quite elaborate passage that I took the court to from the 1924 Spencer Bauer text, and is also consistent with Lord Sumption's characterisation of the doctrine in Virgin Airways. And by that I mean to refer to this idea of the cause of action, which is is a difficult concept, but is whatever it is. The cause of action being presented to the court, proved in court, and then changing, mutating into something that is, in some sense, superior.
I mean, it's a rather mystical doctrine, isn't it? It is the way it's expressed. I mean, that's one of those footnotes. The way Lord Penzance put it seemed to me as a matter of legal terminology, a rather easier way of understanding it. It's really just a rule of law. But once you've got your judgment, then that supplants the original claim you brought and replaces it with new obligations which derive from the judgment.
There's a case in which Lord Bingham made the point that if you are pursuing a cause of action based upon contract of loan, say, which contains detailed provisions about interest, the moment that turns into a monetary judgment made by the court, then the contractual provisions about interest, unless the contract otherwise expressly provides, are displaced, and you are left with your rights to interest in respect to the judgment.
Well, of course, it's for that reason that commercial contracts often contain provisions precisely saying that these will survive any judgment, or as the case may be. And
yes.
Parties can agree whatever they like. And
the parties can contract out of that.
They can contract out of the effect which merger might otherwise bring about.
Yes, yes. So, I doubt I can say more usefully about King and Hall. Could I make a short submission about the Virgin Atlantic case, which I foreshadowed a moment ago? That's at tab 2. And the long and helpful passage in Lord Sumption's judgment starts at page 29, using the bundle pagination. The first sentence of Lord Sumption's discussion indicates how dangerous labels can be in this area. I respectfully adopt that. Then, the court is familiar with this passage. I just want to make a submission about the second and third principles that Lord Sumption identifies. So just above letter D, secondly, there is the principle, which is not easily described as a species of estoppel, that where the claimant succeeded in the first action and does not challenge the outcome, he may not bring a second action on the same cause of action, for example, to recover further damages, see, conquer and boot. Then, third, there is the doctrine of merger. The court knows what Lord Sumption has said about the doctrine of merger. I do submit that there is no real difference between what is sometimes known as the rule in conquer and boot and the doctrine of merger. In Conquer and Boot, not in the bundle, but it is referred to in a case I can go to in a moment. In Conquer and Boot, the claim, as I recall, concerned a building contract, and the claimant brought an action based upon poor workmanship, recovered some money, and then sought to bring a second action based on inadequate materials, and it was held that the second action was barred. And the books sometimes say, well, the second action was barred by the rule in Conquer and Boot, which doesn't take the matter very much further, but in substance it was barred by the doctrine of merger, however you define that doctrine. And if I may just give the court, please, the reference to Conquer and Boot, which one can find in the Republic of India case. If one turns to tab 4, and if one turns up bundle page number 84, that's bundle page number 84, is in this passage, particularly in the lower part on the second half of the page, it's considering the familiar question, are we here looking at one cause of action or two causes of action? And as the court knows, that question arises in many cases and often gives rise to factual difficulties. Just above letter G, Lord Gough refers to conquer and boot. And at the foot of the page below H, Lord Gough cites a passage from Mr Justice Talbot's judgment. Here there is but one promise to complete the bungalow and so forth. One reads what's said there. The test, at the end of that passage, the test whether a previous action is a bar is not whether the damages sought to be recovered are different, but whether the cause of action is the same. And then Mr Justice Talbot is quoted in the following terms, I think, therefore, that the plea of res judicata or judgment recovered is an answer to the whole of this action, and that the defendant is entitled to judgment. So there, the plea, and it shows how the terminology can be tricky, the plea is described as being one of res judicata, which in a sense it is, or a plea of judgment recovered, which is very close to the terminology used by Mr Spencer Bauer in relation to the merger. And I submit that in substance, that is a merger. And that's really all I need to say.
I'd read Lord Sumption as distinguishing them, at least in part, these the second and third principles, on the basis that they have different rationales. Because he says, and different legal characters. There's two bases, I would have thought. The middle of page 29 of our bundle,
Yes.
page 180, he says that the merger doctrine is a substantive rule about the legal effect of an English judgment. This sort of bit of theology. And down at the bottom, just right at the end of paragraph 17, he distinguishes possibly the doctrine of merger from the other rules as not necessarily relying on the underlying policy against abusive proceedings.
Yeah.
So he seems to be treating them as having a real distinction, even though their effects may be the same.
Yes. Well, I respectfully entirely agree respectfully with that analysis of what Lord Sumption is saying there. My submission is that although the doctrine of merger does have the, in your Lordship's term, theological or quasi-theological underpinning that we know about, my submission is that in substance it really comes to the same thing, or much the same thing, as the so-called rule in conquer and boot. Namely, if you recover, if you obtain or recover a coercive judgment on a single cause of action, that is it. You can't do it again. You are barred from bringing a second action on that cause of action. And whether one gets to that conclusion by the quasi-theological route or by a route involving consideration of procedural abuse and so forth may ultimately not matter. What of course is critical, though, for the purposes of the present argument, is that if merger is engaged, it is completely inflexible. There is no qualification, no way out of it on the basis that, oh well, on a broad appraisal of the merits, the claimant should not be shut out. The next case in the bundle at tab 3 is the Clark case. May I make a very short submission about that? I do respectfully submit that is a case which does not provide very much assistance in relation to the issue that is presently before the court. It is a case which is firmly set in the context of the Ombudsman scheme. It is a case in which Lady Justice Arden did not have the advantage of having cited to her Lord Sumption's approach to the taxonomy that applies here.
But I don't think she suffered as a result of that, because she didn't, I mean, it wouldn't have helped her very much, I don't think. At least she adopts an approach which, as I read her judgment, is in keeping probably with what Lord Sumption says.
It,
I mean, she discusses merger, but as I read it, she doesn't decide the case.
She
on the
doesn't.
basis of merger.
She doesn't. She doesn't. And the two, very, very short, the two references, internal references, which show that the case is not decided by her on the basis or by reference to the doctrine of merger, are these. Bundle page 58, paragraph 50.
Sorry, bundle.
Bundle page 58, paragraph 50.
Paragraph 50.
Paragraph 50. Although it is apparent that this case was argued as one of merger below, the parties have argued this appeal on the basis of the more extensive requirements of res judicata. And to the same effect, at page number 65, paragraph 93, Lady Justice Arden says in terms that given her treatment of the principle of res judicata, she did not need to consider whether merger
Yes.
is available. So I respectfully submit that is an ombudsman-specific case in any event, and her ladyship disavowed any detailed consideration of the concept of merger.
And in the terminology of Lord Sumption, it's a case of cause of action estoppel, is that right?
Yes.
And the only issue really is whether that doctrine extends to beyond court decisions to decisions of an ombudsman. The answer is yes, it does.
The answer on that authority is yes. Exactly. Well, also my own friend has cited in his skeleton argument a number of other cases, 2 or 3 English cases and some from the Commonwealth. He has made his submissions in writing his skeleton argument. He's not sought to develop those orally. I've responded briefly in writing in my skeleton argument, and I don't, unless invited to do so, which I don't expect I will be, I don't intend to develop those submissions orally. I've already made a short submission about the Farrer case, which, if anything, is helpful to my arguments. I note, in case the court is interested in the rather difficult case of tab 7, called Serrao and Noel, I simply note in relation to that Lord Justice Sales, in the Farrer case, held expressly that Serrao and Noel is, albeit somewhat opaque, is a case that should be treated as one involving the application of the Henderson and Henderson principle. So that, if Lord Justice Sales is right about that, then that case takes us nowhere. And I've got nothing to add to my written submissions in relation to the other cases for this very simple reason. None of the other cases do what my learned friend's argument would really like them to do, which would be to consider a case in which a claimant obtained a pure declaratory judgment and was thereafter barred from bringing a second action by the application of the doctrine of merger. None of them do that, or it's not suggested that any of them come close to doing that. So I doubt, respectfully, that I need to take up the court's time with any of those other authorities. I'm going to be very economical indeed with my second main argument in this case, which rests upon a short passage in Partners Company Law, which I've identified in my written submissions. I'm a little gloomy about my prospects of winning this appeal on that point.
But just let's have a look at the passage.
If I lose on the merger.
This is.
You're not exactly encouraging us.
No, you're not. But this is a tab 17. It looks as if it's a short passage. I just like to see
Yes.
what the point is actually.
This is the different cause of action point. Isn't it?
Yes, it is.
Yeah.
It is. I strongly urge the argument that one doesn't get to this point, but if one
No,
does,
I understand.
Yeah.
But it's
it's,
so this is the nature of the liability. The shareholder is only bound to pay an accord, yes?
yes. The the passage on which I rely is the second of the two extracts from Palmer.
Oh, sorry, there were two other.
It's 6.2,
Oh, yeah.
6.233.
Yeah, sorry, I missed it. 6 point, under the heading company as a going concern, right. Which prevents, oh yes. Right, the shareholder remains liable for all sums payable. This creates a new, I see this creates a new obligation as a debtor.
Those obviously the words on which I fasten. This creates a new obligation as a debtor. That must be as opposed to a shareholder with special status of a shareholder, which can be enforced by an action. And then reading on a couple of lines, the company can never recover more than the difference between the amount payable on the shares and the amount received from subsequent holders of the shares. My learned friend makes the point that on the facts of this case, it was very improbable that any further sum would be received by the company for the shares on a resale following forfeiture. That may be, but that, with respect, is not relevant. It does not address the analysis as a matter of principle.
Yeah, okay.
And I do submit that there is a difference between the two liabilities. It may be a narrow technical difference, but that's all I need to escape from the application of the doctrine of merger.
Yeah.
If the doctrine is engaged at all.
Right. Okay, thank you.
So I was hoping to save a little time, but I don't want the court to think that I'm abandoning that point. I'm not.
No,
It's soundly based
thank you.
on the leading textbook.
On one of the leading textbooks.
One of the leading textbooks in that field. There are more textbooks in that field than there are in the field of merger. My lords, I think those are my submissions, unless there's any matter on which I can assist further.
I don't think so. I mean, it really, I mean, because it hasn't arisen in a previous case, we have to decide this issue by reference to the principle on which this doctrine of merger depends. I mean, I don't myself think that it's likely that the court would wish to develop the doctrine of merger beyond the point that it's already reached. I mean, in other words, it would be a question of applying the doctrine, the existing doctrine, to a case involving a declaration. And to be fair, Mr. Temminck isn't inviting us to say, well, we should develop it to include a declaration. There's no need to do that. But I mean, the difficulty is that a lot of the statements, I mean, they're just not talking about declarations, but we can't deduce a great deal from that. We have to try and identify, well, what is the real basis of this? And is that a basis which would encompass a declaratory judgment or not? But speaking entirely for myself, I think that is if you like, the difficult issue in this case.
Well, Lord, I entirely agree, subject to one small qualification. I do submit that if the court were to uphold this appeal and find in favour of my learned friend's submissions, that in substance would be an extension of the doctrine of merger.
Well, that's what I'm saying. I see. You would say, why would you say it wasn't?
Because it would be the first occasion that we know of in which the doctrine had been applied in a case where the claimant in the first proceedings had obtained merely a declaration.
But as I say, I'm not sure one can read a great deal into that. I mean, to be frank, the number of cases where a party issues proceedings for just declaratory relief, where they could seek further relief as well, but don't, are not actually all that common.
No.
I'm not saying they don't happen. Clearly they do. This isn't a unique case, but it's not that usual. So it's not entirely surprising that the point has not arisen before.
It's not. It's possible to understand how it might have come about that the point has not arisen before. Nevertheless, it is striking that, given what is said in the main textbook, the point has not arisen over the last 90 something years.
No.
And there are areas that we haven't really been discussing today. There are areas of legal activity in which parties do content themselves with declarations. For instance, in the field of judicial review, the relief that is granted in JR cases sometimes consists of a declaration, and only a declaration. It is possible in that field to couple the claim for a declaration with a claim for damages, which can then be considered by the court. But what if a party succeeds on a JR application, obtains a declaration, then doesn't get further satisfaction, and sometime later, perfectly understandably, comes back to court in a new action saying, right, I want compensation for the adverse consequences of what has occurred. My learned friend's theory will then be engaged, potentially. Right, really at the heart, and I'm returning where I started.
I think that
Whence I started, I'm turning to
complicated what you're raising there.
Yes.
I mean, are you postulating that the applicant, the claimant, comes back on a further judicial review application?
No, with a new civil action seeking damages.
Well,
Founding on the.
that's rather odd. Why was the original action not brought in ordinary proceedings? I mean, if the public authority has committed a tort, then you wouldn't need to go by way of judicial review.
Well, if the public authority has acted unlawfully in some way, maybe in contravention of the some convention right, you can have a situation in which the claimant takes immediate action, needs to obviously to act within 3 months, takes immediate action, obtains a declaration clarifying the law, hopes that things will then sort themselves out, but they're not sorted out, and sometime later the claimant wishes to seek compensation. That claimant, if my own friend is right, would then be at risk of a technical merger argument being advanced to the effect that you had to get monetary relief at the same time as you obtained your declaratory relief. And that would be very undesirably inflexible. Really, I mean,
we haven't got any examples of that happening, and what in practice happens. I mean, immigration cases involving allegations of unlawful detention are a typical example of the sort of fact situation that you're contemplating. And I can't think of a case where the potential claim for damages was held back while the judicial review was pursued to establish that the immigration detention was unlawful. They usually get brought quite prominently, and then they get sent off to the county court for a resolution afterwards.
Oh yes,
so it's quite difficult to sort of envisage the theoretical problem in a concrete case.
Well, my own friend knows that what I'm about to say because I've said it before below. I was involved in a case involving the unlawful retrospective alteration of things called feed-in tariffs, which were benefits paid to those who install green apparatus. And the claim was brought initially on the basis of a JR application, which was successful and obtained a ruling as to the statute which favoured the claimants, and then sometime later civil proceedings were brought for compensation against the department, which travelled towards trial, and which arguably, if my own friend is right, might have been vulnerable to a merger argument if it were a good one. I don't really seek to persuade the court that this problem is going to crop up all the time. It's not.
No.
But I do, and before I sit down, if I may just say this, in danger of repeating myself, I do urge that the underlying policy considerations that we are all familiar with are best served by allowing this type of situation to be dealt with by applying the Henderson and Henderson Johnson Accord.
No, I follow that. I follow
It
that,
already
which
has
is
that.
perhaps what lay behind my remark that it was very unlikely that the courts now would wish to extend the doctrine of merger because there are other tools available to meet that. But so we just have to identify the existing boundary of the doctrine and see whether it applies to claims for declaratory relief.
According to Mr. Spencer Bauer and
Yes?
the later authors, it would be an extension. And
Yes.
it is, for the reasons I've given, it would be also an undesirable extension if it were.
No, I take that.
And
Okay.
the courts now are very keen, of course, on litigants who come before them, bringing every point before the court that ought to be placed before the court. And that is why there is the so-called allotted principle, which the court will be familiar with, I expect, which actually requires a litigant to engage with the court in its case management powers if the litigant is contemplating further proceedings. Another salutary principle could be engaged here, might shut out this type of claim, but it doesn't here because in this case, my client was candid about its intentions, and there was no Henderson and Henderson type abuse. Those are my submissions.
Anything you want to ask? Mark, anything you want to ask? Well, thank you very much indeed, Mr. Barnes. Yes, Mr. Taylor.
It's interesting, isn't it, listening to the suggestion that there are different doctrines in a litigant's armoury that can be deployed. And there are. Of course there are. And there are different reliefs that one can seek and different ways of casting a cause of a claim when you have a cause of action. But that doesn't mean you can just wipe them out because you might be able to rely on a different doctrine. Indeed, maybe if this ever comes back to another court for determination, we'll be pleading the Aldi principles. But it may have been an error. You know, they chose not to litigate out all of the relief that they had available to them. And it may be that the reason there aren't many of these cases is because most lawyers, or some lawyers, are wary of that, and they bring before the court all of the relief they seek at the same time. I'm going to deal with, I think, just three things. First, the hypotheticals, which are, we can all construct hypotheticals and say they're very difficult. And indeed they usually are, because we're trying to illustrate the point. But I say this about the hypothetical examples that one might throw at us. The first is that the court's declaratory powers are broad and discretionary, and the relief doesn't necessarily rely on any strict legal formula. Even if certain factual matters are relied upon in order to obtain some sort of relief, it doesn't matter. It doesn't mean that that is based upon findings of fact that relate to a recognisable cause of action. It's not all of it. Doesn't meet all of the test when you seek some sorts of relief. So, what you have to do in each of these hypothetical examples first is decide or consider: are the causes of action truly identical? Secondly, is the declaration truly on the cause of action? Or as the Chief Master put it, is it really based upon findings of fact that relate to a recognisable cause of action? And as a last resort, we always say the Indian grace is binding law, reflecting a centuries-old policy balance. And the policy balance is that you look to the underlying facts, and if the underlying facts are identical, the causes of action are identical and cannot be reasserted. And like any bright line, hard letter law doctrine, there are going to be hard cases where the curtain comes down and cuts out a litigant. In my learned friend's hypothetical about the clarification of the law or a contractual interpretation point, causes of action are not the same, And the court, when asked to make a declaration about the contractual interpretation, isn't making any determination about a past set of facts at all. It's just looking at the law and determining it. So the cause of action about payment is separate and it's different, and that's why it's not identical and wouldn't be caught by the doctrine.
Sorry, let's just look at that. So the example that Mr. Lawrence gave us was of the long-term contract with annual or other regular payments, but there was a dispute had arisen between the parties as to the amount to be paid under that clause, whether it was 100 or 200, for example. And at the time that one of the parties issues proceedings for a declaration as to the amount due under the that clause, there are arrears. On the claimant's interpretation, there are arrears because the defendant has been paying at the lower rate for which it contends. The claimant issues proceedings for a declaration as to the true meaning of the clause, as to what the amount payable is. Now, in those circumstances, would the claimant be prevented by the doctrine of merger from subsequently issuing proceedings to recover, as it were, the shortfalls up to which had accrued due up to the date of the issue of the proceeding?
Well, it probably depends on what they sought in the declaration, because if there are findings of fact, if the declaration is based upon findings of fact that relate to the past non-payment, then yes, they would be bound and the doctrine would apply. If instead they come for a declaration and they say, what does this term of the contract mean? The court looks at it as a Part 8 claim and says that term of the contract means £200 a year is payable, then there is not that finding from the court on the underlying cause of action.
So if claimant seeks a declaration without adducing evidence as to what's happened in the past, then merger wouldn't apply.
Are the causes of action identical? Is the declaration on the cause of action? Is it based upon findings of fact that relate to a recognisable cause of action?
Yes, I see.
We did deal with Lady Justice Arden's analysis in the Ombudsman case, in the Clark and in Focus, in our skeleton. And in footnote 13 at page 12 of the skeleton, 26 of the bundle, we said Lady Justice Arden analysed this case as a cause of action estoppel or res judicata rather than merger case.
Sorry, you're reading from where?
I'm reading from my skeleton argument. It's
yes.
page 26 of the bundle.
Yes.
It's the footnote.
Yes.
It's probably most convenient just to read footnote 13. If that's...
Yeah. Well, sorry. I mean, you agree, do you, or not, that Lady Justice Arden did not, I would say expressly, did not treat it as a case of merger?
I do agree with that.
Yes.
I'm going to be bold, though, and say she was wrong not to treat it as a merger case, because cause of action estoppel is about preventing...
So, and Lady Justice Black equally was wrong because she agreed it was a res judicata case.
Yeah.
Yes, okay. So...
because
you would say that she was right in the approach, just wrong with the label.
Absolutely.
Yeah.
But does this go back to the status of an ombudsman's award, do you think?
No, it goes to the distinction that Lord Sumption drew between cause of action estoppel, which prevents contradiction, and merger, which prevents reassertion. So the reason that Clark case, I say, was properly a merger case was because it was about not being allowed to run the same argument again that had been run in front of the Ombudsman. It wasn't a contradiction case. They didn't want to contradict the Ombudsman at all. They said, you were right, Ombudsman, to find that we were treated badly. So that's why I say the analysis about it being a cause of
So you
action.
say it's not a res judicata case. Is that right?
Well,
In the portmanteau term, it is.
exactly that.
Yes.
So it's not a cause of action estoppel
Sorry.
species of res judicata. It's a merger species of res judicata. Except Lord Sumption says the doctrine of merger is not properly used as in a res judicata sense.
Yes, all right.
But if it is properly analysed as a merger case, then one comes back to the problem, on what conceivable basis can one properly treat an ombudsman decision as something which fulfills having the same mystical effect as which was explained in by Baron Park.
Well, I think that the answer is that when you accept the Ombudsman's decision, it becomes final and binding against both parties. And so it's then of the order. It's reducing this whole concept is reducing things into a certainty. So rather than having a cause of action where you've got an assertion, you haven't paid, or there's a debt, you have a decision, a judicial decision, and I'm using judicial with a small j, which says it's not just a cause of action now. We've made a determination of it. It's based on we've made findings which are based on the cause of action.
And in that context, the statutory underpinning, if one can use that term, may make it easier to equate the Ombudsman's decision and its acceptance together.
Yes,
with the judgment of the court.
the sort of slightly charming arrogance of only applying to English judgments has gone.
Well, but hold on. Just pause there. English judgments, yes, but judgments.
Judgments, yes.
Well, no, not just judgments, because we know it applies also to arbitration awards. There's authority on that at the moment.
Yes, I think I can't remember where that was. But...
Well, it's. I was just going to.
I mean, at common law, it did not apply to foreign judgments. That's why statute intervened.
Absolutely, correct.
So why should common law recognise? You said it has extended it to arbitration awards.
I do. Because it was a ludicrous distinction.
Well, hold on. It all depends what the reason was.
Yeah.
Just show us again the arbitration award point.
I will. So I think probably E. and Brian Smith might be the one way to do that.
I mean, Lord Sumption definitely puts it in terms of the particular significance of a judgment.
The E. and Brian Smith is at tab 8 of the authorities bundle.
This is Mr. Justice Branson's decision.
I'm just looking for the.
And the judge was obviously very anxious to avoid any kind of merger argument succeeding.
Yeah, he
As
was.
courts tend to do, he managed to find a way around it by adopting a rather narrow view of what had happened at the arbitration.
Well, that case failed because precisely that judicial quick step around,
Yes.
around what had happened in the arbitration and the relief sought.
Yeah.
Well, I'm not finding a really authoritative issue, a piece of the judgment which is going to help your lordship. I'm sorry.
Well, I mean, if one looks at page 311, for example, having referred to Conquer and Boot and Henderson, the judge said at the bottom that he would assume, for the purposes of deciding the point, that Mr. Miller's argument was correct when he says that there is in this matter only one cause of action. Therefore, the parties, when they came to arbitration, should have raised any other question arising from the breach of contract, and that if the rule was to apply, the buyers should have claimed damages for non-delivery at that reference and can't ask for damages in a subsequent arbitration. But I'm just really looking to see whether that's being put on the basis of sort of a Henderson and Henderson abuse of process type of argument, or whether it's being put on this substantive rule of law that is merger.
Certainly the way those questions are formulated rather is very redundant of Henderson and Henderson,
Jeez.
which the judge has just referred to, of course, higher up on page 311.
Well, can I, having said that's the best exponent of it, can I instead pray and aid Spencer, Bower and Handley?
Yes, certainly. Right.
And try and skip away from the action which the claim.
Yes, okay. So they say that.
At
They
2002, so it's page 251 in the authorities bundle.
say 251.
It's page 251 in the authorities bundle. It's the extract from the more recent edition, the most recent edition, so it's very handy. 2002, it's asserted any cause of action successfully taken to arbitration merges in the award. Fortunately, this one's footnoted, and there's reference to Mokes and Blackwell Colliery in 1917. And then Ayscough and Sheed Thompson and Company, H.E. Daniels and Carmel Exporters and Importers.
Yeah, okay, well that makes the point, certainly.
Well, I'm not suggesting for a moment that what's written in Spencer, Bower and Handley is something your lordships can rely on without...
No, but as you say, there are some authorities footnoted there, yes. Yeah, okay, thank you.
My Lord, Lord Justice David Richards asked me about double damages cases, and I skipped over it because I had just put them in the skeleton.
Yeah.
But Farah, of course, wasn't a double damages case. That was trespass and then damages.
Yes. Yes.
Sarawa and Noel was delivery up and then claim for a conversion. E.E. and Brian Smith was the arbitral award and then about a declaration on fitness of white peas, and then a claim for damages. Sahin, the Australian case, was judgment on misleading and deceptive conduct contrary to statute, and then a claim for deceit afterwards. So that was a declaration case and then a damages case. King and Lintrose sought a declaration on a breach of fiduciary duty, then equitable compensation. And so in our skeleton, we have set out quite a lot of cases which aren't just it's negligence and then a breach of contract.
Okay.
And the reason we put those cases in was not to show that those are declaration cases where a plea of merger wins. It was to show that it's the remedy is not important, it's the cause of action that's important at the beginning.
Yeah.
Now, Melanie, this is I think the last point I really need to deal with, and then I'll end on something the Chief Master said. The learned friend said that the doctrine needs to be, I think it is expanded, because he took your lordships to the 6 principles set out in Spencer, Bower and Handley as to what constitutes the ingredients, if you like, of the doctrine of merger, but then added another one which said it has to be enforceable. Learned friend said it has to be immediately enforceable, subject to any stays for an appeal. Yeah. And that I'm afraid is an invention. It's a new provision which is not made out by any of the authorities, and it adds an extra layer of technicality to what is already a pretty technical doctrine. The judgment could have been enforced. They could have obtained an injunction, for instance, to compel the surrender of the shares, because they had all the declaratory relief they needed. You're enforcing the judgment in that case, is what he said. Now, in order to determine whether they obtained a declaration, the court has to determine all of the issues in the cause of action. And if it's done that, then the doctrine is engaged. Now, in the first edition of Spencer, Bower and Handley, that was the sheet that the sheets that the learned friend ended up after the short adjournment.
Yeah.
There is a passage at page 184 of the extract. It's very near the end, the penultimate page of the clip. It's at paragraph 315. And the passage at 315 and 316 undermines what my learned friend said about the further requirement for the need for enforceability. At 315 it says, the question of whether there was a former recovery in the above sense is one of fact, and as such must be established by evidence. If it be not shown that in the former proceedings the party recovered the precise relief alleged, whether by a judgment in an action, by an award in an arbitration, or by a conviction in a criminal case, the plea fails. It goes on, recovery, however, means no more than recovery of the right as judicially declared to the relief granted. It does not mean physical or actual recovery of the money or other relief awarded by the judgment. The original cause of action is merged in the judgment as soon as it has been pronounced. It follows that everything which happens afterwards in relation to its enforcement or fruition is irrelevant. Accordingly, it's been held that a plea of former recovery, otherwise good, is none the less so merely because the former judgment was infructuous. Maybe my Lord Justice Warby will help me with that one in a moment. The judgment creditor being either unwilling or unable to obtain satisfaction by payment, execution or otherwise, or merely because the party after the judgment elected to abandon his rights of execution by nolle prosequi or other formal act, as distinct from an election to discontinue before judgment, or merely because in county court proceedings the party elected to abandon the excess over the pecuniary limit of the jurisdiction pursuant to the provisions of the statute.
But surely all that language presupposes that you have a money judgment. I mean, this is talking about enforcement by writs of FIFA or whatever they're called nowadays, you know, all that kind of stuff.
Well, it might be, but there is a definition of recovery. Well, there isn't a definition of recovery.
No.
You get a clue as to why former recovery suddenly comes into the vocabulary here, right at the very beginning of this extract on the first page of the textbook, and it's simply this: that was the lexicography, the taxonomy of the day. One recovered a judgment in an action, and we can see that. At 295, it says the rule may be summarily stated as follows. Any person in whose favour an English judicial tribunal of competent jurisdiction has pronounced a final judgment, whether civil or criminal, is precluded from afterwards recovering before any English tribunal a second judgment for the same civil relief on the same cause of action, or a second judgment or conviction for the same offence against the same party. And I don't think it can be right to say it must be limited, therefore, to damages claims, because why else would it refer to criminal proceedings, which obviously won't have any sort of money recovery attached to them, And indeed, when it talks about recovering a judgment, it has nothing to do with sums of money in there at all.
What these passages do seem to do, and here we're back to terminology, is to talk almost universally, if not universally, about the judgment for the same relief. And in paragraph 315, which you're relying on, whether there was a form of recovery must be established by evidence if it's not shown the party recovered the precise relief alleged. So we're back to the same problem. I'm not saying that these are dispositive, but they do talk about cause of action for certain relief.
Yes, because I accept that this doctrine won't apply for every single declaration that's sought from the court, because I do put limits on the scope of the doctrine. I've set them out. I'm not going to go through them again unless it would be helpful. But I do recognise that there are circumstances in which one can apply to the court, obtain satisfaction in that application. And I'm using my language hopefully fairly carefully, but not thereby completely, I'm going to use this language carefully as well, banjacks the chance of coming back to court and obtaining satisfaction, so long as it's not in respect of the same cause of action or a judgment on the same cause of action arising from that determination of past facts. And that was really also why I drew attention, my friend was kind just to go to that footnote at W on the bottom of page 178 of the extract, because it puts the limits on the extent of the doctrine. And I would also just say that in the Authorities Bundle 249, in the most recent edition of Spencer, Barron Handley, at paragraph 1903, when we have the list of what's required for the doctrine to be activated, there's absolutely nothing there about enforceability at all. It doesn't make the list. I may be repeating myself, so I'll be very quick on this. But in 20.08, in the Spencer, Barron Handley most recent edition, the sort of active ingredient, if you like, in the list is a decision capable of supporting an action. Those are the words used. It doesn't say it's not a final judgment capable of founding enforcement, but rather it's a judgment on a cause of action. And that's what we say they had in this case. There is nothing further to be done judicially in this second claim to render it effective and enforceable, because all of the elements of their cause of action have previously been determined. Indeed, in this claim, the claimants have sought summary judgment on the basis of the findings already made by Martin Griffiths QC. And they make that claim for summary judgment relying on nothing more than the pleadings that they already made in the first claim. Now I'm going to end with the wise words of Chief Master Marsh. They're not actually his. He's simply adopting the words of Lord Atkin. May I take your lordships, please, to page 41 in the bundle. No, it's not. It's page 141 in the bundle. And it's paragraph 51. The Chief Master says, the defendant, that was me, says that the facts alleged in the claim amounted to a cause of action entitling the claimant to recover the unpaid amount due for the shares, and cause of action merges with the judgment and the order is thereby extinguished. Mr. Temminck invites the court to have closely in mind the exhortation of Lord Atkin in Workington Harbour and Dock Board against the Trade Indemnity Company Limited in 1938. Lord Atkins says, the result is that the plaintiffs, who appear to have a good cause of action for a considerable sum of money, fail to obtain it, and on what may appear to be technical grounds. Reluctant, however, as a judge may be to fail to give effect to substantial merits, he has to keep in mind principles established for the protection of litigants from oppressive proceedings. There are solid merits behind the maxim nemo debet bis vexari pro una et eadam causa. And as my Lord Justice Henderson will know, that is the principle upon which we rely, or one of the principles upon which we rely.
Was that a merger case, Workington Harbour and Dockport?
I knew I should have done that before I ended about the rhetorical flourish. I can't tell your lordship right at the moment. I'm sorry.
I suspect the answer is no. If it were, it would have been your list.
I think if it were, I would have relied
You
on
would
it
have
very
made something of it.
The principle's good, however.
Very good.
My lords, that's all I have to say.
Any questions? No. All right, thank you very much, Mr. Temming. Thank you both very much for your submissions, written and oral, on what is a rather puzzling, I think, area of the law. We'll take time to consider our judgments. You know the usual procedure. They'll be circulated in the usual way for comments and so on, and handed down remotely. Thank you both very much.